Good afternoon, everyone, and welcome to the Connecticut Paid Leave What You Need to Know workshop. My name is Frank LaMonica, and I'm the chair of the Southeastern Connecticut chapter of SCORE. Our speaker today is Andrea Barton-Reeves, CEO of the Connecticut Paid Family and Medical Leave Insurance Authority. Andrea is the inaugural CEO of the authority and was appointed by Governor Lamont in January of 2020. So it's been a little over a year now, and a lot going on. Looking forward to hearing about this important change to the family and medical leave law in Connecticut. I'll begin our session with a brief introduction to the SCORE organization, and then I'll turn the workshop over to Andrea. So I'll cover who we are at SCORE, where Southeastern Connecticut fits in, what our reach is, our services, how you can engage with SCORE, and then just a couple of webinar logistics, and then I'll turn it over to Andrea. SCORE has a very simple mission to help aspiring and existing businesses succeed. We do not have, we are all volunteers. We do not have any metrics about companies going into business or measuring employment, that type of thing. Our focus, our goal, our mission is outreach, to be available to the community, the small business community, small business owners, to be a sounding board, to be a mentoring resource with you. We have a tremendous group of volunteers, and our goal is to be there for a very early stage or when there are problems, and work with you through those issues. So, facts about SCORE: we are a resource partner of the Small Business Administration. What that means is that our funding nationally comes through the Small Business Administration budget as approved by Congress. SCORE is an independent 501c3 nonprofit organization. We have over 11,000 volunteers now and growing. That might be over 12,000 now, across 300 chapters in the United States and Puerto Rico. We've helped over 10 million people in pursuit of their business goals, and that grows every month. And all services, our workshops, our mentoring, our online programs are offered without charge. Our chapter is Southeastern Connecticut, or SECT for short. We have between 40 and 40 volunteers at any one time, and we bring a diversity of experience and talent, whether it be in starting up business startup experience, manufacturing experience, human resources experiences, marketing, digital marketing strategies, the whole gamut of need now in the current economic environment. You can find us at www.sect.score.org and also on our Facebook page and at Meetup and on LinkedIn. We have been mentoring up until the pandemic in 9 locations throughout Southeastern Connecticut, and we have been now mentoring virtually, but we expect to be going back to a combination at the will or at the need of the client or the mentor, back to virtual. We hope to be going back to in-person mentoring during the fall. Right now, our services offered are our one-on-one mentoring with small business owners. We've, again, do face-to-face or via Zoom right now, and Zoom is working quite well, actually, and our client feedback in our surveys is they like it. It's convenient. They can move them easily if there are issues, and we can meet at a more convenient times of the day for our clients. We can share screens, look at information, so it's actually been quite a robust tool for us in the past year. We also, in between meetings, will connect with our clients via phone and email mentoring follow-up. Our webinars, such as you're on today, has a wide range of webinars. I'll mention where you can find them a little later on, but they run the gamut from all things a small business would require. Online, you'll find templates and tools, a very deep and broad selection of tools for the small business owner. Again, at sec.score.org, there are 300 plus pre-recorded business marketing, finance videos, you name it, we've covered it. And we're keeping it current and relevant for the needs of today. For our workshop, if you like us on Facebook, you'll automatically be notified in your newsfeed of upcoming workshops. You can visit us at our website for a listing of workshops. Actually, I think it's extended out past June now into the fall. And we'd like to remind everyone, workshops are an overview where you can pick up a lot of helpful information, but they are really a lead in to our mentoring services. We can go deeper on these issues with your specific business need in mind. We often work in teams, and we bring in specific, if you need someone on digital marketing, we'll bring someone in. If you need someone on finance, we could bring someone in. So we try and have our mentor team be relevant to your need on that particular day. Again, there's our website. You can go to the tab, Take a Workshop, register through our website, and find a mentor by going through the tab on our website, and you can apply either by phone or electronically. For today's webinar, microphones are on mute. There will be a Q&A session, a live Q&A at the end of the presentation. You can enter your questions at the Q&A at the bottom of your screen. Remember, we are here for you today, so please do engage and ask questions. And afterwards, there'll be a survey. Help us help you. The surveys have been very helpful, especially since we've moved to video and Zoom webinars versus in person, and that you've really had a lot of good ideas to help us be better at serving our community. So we do encourage you to participate in the survey, and you'll receive a copy, a PDF of the presentation when you've completed the survey. So having said that, I will now turn the screen over to Andrea for today's presentation. Andrea, the screen is yours.
Wonderful. Thank you very much. I appreciate that. Let me just take a moment to walk through some of the Zoom logistics of sharing my screen and getting on the right place. So appreciate your indulgence while we do that. There we go. All right. Okay, so this afternoon, I really do appreciate the opportunity to speak with you about the Paid Leave Act and Connecticut Family and Medical Leave. So as I was sharing with Frank before our discussion began this afternoon, it's important to know that there are two components to the way that this law is changing. One is that the current Connecticut Family and Medical Leave Act will change to apply to all employers, and then there will also be a wage replacement component, which is what we manage at the Paid Leave Authority, and I'll talk about both of those today. So just a little bit about me. As Frank had mentioned, I've been appointed by Governor Lamont last January, and I began in my role last March, just right before the pandemic shut down our state and the world. Before that, I was the CEO at HARC in Hartford that supports people with intellectual disabilities and its families. I've been active in the community. I am originally from New Jersey, but I've been in Connecticut for over 25 years. I have a degree in English from Rutgers and a law degree from New York Law School. Today we'll talk about the authority itself, and then I will again speak a bit more about that distinction between family and medical leave and paid family and medical leave, an overview of the leave laws and employers' responsibilities with respect to job protected leave and income replacement, what we do at the authority in both of those respects, a couple of examples of how it looks from both sides of the aisle, and pointing you to some additional resources before we get to our live Q&A session. A bit about the Paid Leave Authority. We have a mission to provide pathways to accessible paid leave benefits. And we do that in part by offering employers and administrators and healthcare professionals an opportunity to access tools so they can better understand the law and to navigate the program. We have 5 primary responsibilities under the statute. They include outreach and engagement. So again, thank you for having us here today. Developing the policies and procedures that are needed to run the program. We established the trust fund contribution rate, which is statutorily set at no more than 0.5%. And we receive those contributions, and that first period just closed in April, so last Friday, April 30th. We audit and approve private plans for those employers that wish to offer their own version of the paid leave law as long as it meets certain statutory criteria. And we administer the paid leave benefits, which will be available starting early next year. What is FMLA and what is paid FML? Family medical leave, for those you may not be familiar with it, is known as the Family and Medical Leave Act. There is both a federal and a state corollary of this law, but both of them do allow employees to take time away from their jobs for certain family and medical reasons. And what's important to note here is that that leave is job protected. That means that if they have worked a requisite amount of time and hours, when they take the leave for reasons under the statute, they are entitled to get their job or a substantially equivalent job back if that job no longer exists when they return from their leave. As we sit here today, both of those laws, while they offer the leave, that leave is unpaid unless that employee has accrued enough time in whatever way their employer manages and measures accruals to take that time with pay. And it may not cover all of the time that they're away. But some employers can adopt policies that provide for income replacement during the leave. Some of them provide paid leave already, and we've certainly encountered that. But some employers require or permit their employees to use their accrual, sick, vacation, or other types of leave while they are out. But the law will change significantly in 2022 with respect to both of these parts of the law. Paid FML, often referred to as the Connecticut Paid Leave Act, provides a source of income replacement when an employee takes time under the Connecticut Family and Medical Leave Act for reasons that are listed under the Act. We do not provide job protected leave. Our role is solely for wage replacement. And the Paid Leave Act provides the income replacement and it establishes the Paid Leave Authority itself. Which employers are covered by the paid leave law? Those employers that are covered are those that have one or more employees working in Connecticut, and that includes not-for-profits and private sector employers that have a unionized workforce. If you're a sole proprietor or a self-employed individual and you choose to opt in, you may do so, but if you do, the statute requires that you remain in the program for a minimum of 3 years. And in addition, if you're a sole proprietor or a self-employed individual and you have employees, while you, as the sole proprietor or self-employed person, have the option of opting in, your employees do not. They must participate in the plan if they are, in fact, employees to whom you issue a W-2. Those employers that are not covered include the federal government and some state of Connecticut employees, except those that are covered public employees, and I'll explain what that is in a moment. The same is true for those that work for municipalities or local or regional boards of education, unless they too have covered public employees. Then the only category of employer that is totally exempt from the covered employers under the statute are non-public elementary or secondary schools, and that is that these two types of employer entities have never participated in family and medical leave in the state, even prior to the implementation of this law. What is a covered public employee? They are all of the non-unionized employees of the state of Connecticut. Those that are unionized may collectively bargain to be included in the program. Employees of municipalities or local or regional boards of education may opt in, if they are unionized, to participate in the program through collective bargaining. If they do so, then the employees of the municipality or the employees of the local or regional board of education, if all of them are then included in the program. So let me just say that again one more time. The municipality is usually excluded as an employer, but if the unionized employees of the municipality collectively bargain to be included in paid leave, then that decision is binding on all of the employees at the workplace, whether they are in the union or not. And the same is true for the local or regional boards of education. And you can see there is a very expansive definition of municipality, which includes the way we usually think about them, towns and cities, and it can include a flood commission, a tourism district, or an authority established by special act. Let's go over the leave laws. There is actually quite a large family of leave laws that everyone may not be familiar with. There is a federal corollary, as I mentioned earlier, to the Family and Medical Leave Act, and that applies to employers that have 50 or more employees. We have a Connecticut Family and Medical Leave law, both of which, both federal and state, have been in place since the mid-1990s. There's also workers' compensation, which many of us are familiar with, the Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practice Act, which is commonly known as SFIPA. And all of these laws, the ADA, the Pregnancy Disability, and SFIPA, if they apply to a workplace of 15 or more employees, require that employer to engage in some level of reasonable accommodation, meaning that they need to make an effort to make a reasonable change to their workplace or schedule in order to allow a person who's covered by one of these acts to continue to work. And we can teach a whole seminar on each one of these individually, and I won't do that today. But there was, until now, only one law that really offered any income replacement during leave, and that was workers' compensation. But starting next year, there will be an additional law, the Paid Leave Act, that will offer income replacement, as well as an opportunity to take leave, even without compensation, as I mentioned, because the law is changing. Reasons for leave or income replacement are essentially the same, and these will change in the beginning of next year. Leave will be available to create or expand your family through birth, adoption, or foster placement, also known as bonding leave. Leave can be taken to care for a family member with a serious health condition or for your own serious health condition, which can include serving as an organ or bone marrow donor or a pregnancy. A special leave is available for a family member who is injured in the military during active duty, known as military caregiver leave. There's qualifying exigency leave when a family member is called to overseas active duty, and they can take time to put their affairs in order, arrange for childcare, take care of banking matters, and the like. And what is unique to Connecticut is there are 12 days available for family violence leave. So a person who is a victim of family violence, also known as domestic violence, there is already a law on the books in our state that allows a person to take up to 12 days of unpaid leave to address any issues that arise from family violence. That person will now be able to take that leave under the Connecticut Paid Leave Act next year to address those same concerns. There are changes to caregiver leave that are different than the law looks now. So now under the new law, starting next year, an employee will be able to take caregiver leave and apply for paid leave benefits if they are caring for a parent, a spouse, a son or a daughter of any age. And this is significant because the law right now limits the ability to take care of a son or daughter to a person who is a minor, or if they're over 18, that son or daughter has to have a disability. A sibling, a grandparent, grandchildren, or a person with whom the employee has a blood or affinity relationship that's equivalent to any of these relationships that are listed here. And that is known as related by affinity, and the definition is there at the top of the screen. The relationship by affinity or related by affinity is most commonly known to people if you look at the second bullet under the examples. So often there are people who are living together in a familial spouse-like relationship, although they may not be married to one another. And if they were to need to take time off to care for the person they consider to be their spouse, that is not a possibility right now without taking vacation time, and there is absolutely no wage replacement. And there's no job protection because caring for someone who is not your legal spouse is not a covered person under the statute, under federal or state law right now. When the law changes next year, that person would be able to take time off to be with the person they consider to be their spouse if they have a serious health condition. So what are the eligibility requirements? For a person to enjoy job protected leave, as I mentioned earlier, the ability to get your job or a substantially equivalent job back after you take leave, they will have to have been with the employer for at least 3 months, but there is no hours worked requirement. And this distinction is important because right now, a person has to work at least 1,000 hours with their employer, and they have to have worked a year in order to get job protection, and that will change. The job protection is determined by the employer. So the employer will be determining whether the person has worked long enough to have job protection attached when they take leave. The paid leave benefits are determined by the paid leave authority, and we measure that by determining whether or not the person has earned $2,325 in the highest earning quarter of the past 4 of the 5 quarters before they apply for their benefits. And that can be earned by multiple and from working for multiple employers. They have to have a reason for leave under the statute, of course. They have to have been currently working and employed in the state, or at the time that they apply, they had to have been working for a Connecticut employer for the past 12 weeks. And as I mentioned earlier, sole proprietors and self-employed individuals who opted into the program also obviously may apply for benefits as well. Length of the leave is as it's outlined here, and it's the same for paid or job protected leave. 12 weeks in a 12-month period for all of the reasons except there's 26 weeks available in a 12-month period for military caregiver leave, 12 days for family violence, and an additional 2 weeks available if a person is experiencing incapacitation during their pregnancy. Now, let's speak about the employer's responsibilities. What are the employer's responsibilities with respect to the law as it'll be changing? We ask a few things of you to please, if you have not already, register your business at ctpaidleave.org, calculate your employee contributions, which I mentioned were actually due last Friday, and to remit those contributions on a quarterly basis. And I will speak to what happens if you've missed all of this. There is a way to catch up and to make your employees whole with respect to their contributions. After the law changes and after 1/1/2022, we'll ask that you respond to our request to confirm that employees will be away and whether or not there are any other benefits that they should be availing themselves of before they access benefits at the Paid Leave Authority. Now, right now, if you don't already have one, you might want to think about developing an FMLA policy and forms. We will be doing this at the Paid Leave Authority, but they may not be available as early as you would like. We're actually working on them now. But please let your employees know about what that policy is. I say this because the Family and Medical Leave Act only applied to employers that had 75 more employees in the state of Connecticut or 50 or more if they were covering federal leave. So for much smaller employers, this is an entirely new world, and we understand that. And coming late summer, early fall, we will be providing more directed and focused education about family and medical leave itself. After the next year, we will begin to process leave requests at the Paid Leave Authority, but we will also be reaching out to you as employers, asking you to confirm the reasons for leave, whether or not that person has been with you 3 months or more and they have job protection. And we'll also ask you to keep track of their leave usage, and we will have that leave usage as well, so that we will be able to compare notes and make sure that the person is taking the leave as has been determined and they return to the workplace when they said that they would. Registration process, if you haven't already done this, is really quite simple. You can go directly to our website, ctpaidleave.org. At the very beginning, as soon as you land on that page, there is a button that will allow you to get started on the process. You'll need to create an account, and then once you do that, you'll come back to our site. You'll be directed back to our site, I should say, and then you will choose a tab that is appropriate to you, and the registration process will begin, and it takes about 10 minutes. There are checklists that are here, so you can gather the information you need before you start the process to minimize frustration around that. A bit about the contributions that employees are making. This fund is completely employee funded, and those contributions are post-tax, and they are based on FICA wages that you may already be calculating for your employees. Businesses have up until the end of June to collect those contributions. So if you have not started in January, you can collect from pay that you are paying through the end of June to catch up. And you can do that by collecting up to an additional 1% on top of the 0.5% that employees should have been contributing since the beginning of the year. If that still isn't sufficient for you to make up what should have been contributed from January to June, then we ask you to reach out to the Paid Leave Authority directly, where we can work with you in setting up a payment schedule so that you can get completely caught up. Social Security, the Social Security contribution limit is the cap for making contributions to the authority. So nothing above 142,800 will be collected at the 0.5%. You should be sending those payments in no later than 30 days after the end of each quarter, and those dates are listed there. And all of the payments are made through ctpayleave.org. And when you are in a position to make those payments, you will log in using your login information, and it will walk you through it. If you happen to be using a third-party administrator, they will normally file this on your behalf. So whether it's one of the larger payroll companies or your tax accountants, whoever might be doing that for you, they can file on your behalf if you choose for them to do so. All right, so let's talk about what happens when the person is applying to the employer for job protected leave. It is the employee's responsibility to let you know when they need time off from work, and that time is related to a family and medical leave reason. They should give you at least 30 days advance notice where the need for a leave is foreseeable. If it's a planned surgery or some other kind of procedure, or they know that someone that they need to care for will need leave in advance, they should tell you that. But it also should be as soon as practicable if that leave is not foreseeable, i.e. an emergency. The employer is going to determine whether or not the person is eligible for family and medical leave. And that just means looking down that list of reasons that you will get that are in this presentation and seeing if it meets any of those criteria. If they have their own serious health condition, you won't be making this decision on your own because there are forms that they need to bring back to you, and we will be developing those forms. Now after they bring that documentation, you have 2 days to let them know whether or not, let me say it a different way. Once they let you know that they need it, and you have 2 days to let them know whether or not they're eligible. And this is not necessarily the leave approval. The employee needs to bring you additional documentation, and some of the examples you see are there. The medical certification, any adoption documents, or military records. They have 15 days in which to do this. If they can't do that in 15 days, you can give them an additional 15 days, but beyond that, as the employer, you have the right to deny the leave, and they have to then re-notify you and provide that documentation within the prescribed period of time. Let's assume that the person has notified the employer, they've brought in the appropriate documentation in the right period of time. You have 2 business days once you've received the documentation to let the employee know whether or not their leave has been approved. You also have to let them know whether or not you require them to use their paid leave accruals, meaning their vacation or their sick or their PTO, how and when they need to report in and let you know. And depending on the type of work that they're doing, you might actually require them to have a fitness for duty before they're returning to work, if it is in fact a leave they're taking for their own serious health condition. Now, the employee reports to the employer when they are actually taking their leave, and it cannot exceed more than 12 weeks. For those employers who have never done this before, I know this can be very overwhelming. We're just laying this out as the general path that you'll follow. And as I said, as the time gets closer, we will provide you with much more detail and support on actually how to do this. But again, don't forget to consider whether the employee may be eligible for job protected leave under the other laws that I outlined before. So they may be, depending on the size of your business, you may be subject to the leave under, or reasonable accommodation under, the Americans with Disabilities Act, the Pregnancy Disability Act, or the Connecticut Fair Employment Practice Act. We've actually heard from a lot of employers that they didn't even know that the size of their business made them eligible or made them liable under these laws to provide these kinds of protections. So we're happy to also provide that kind of education as well. And we can also hold another seminar to teach more about that. What's the employer's role in determining eligibility for income replacement? Now, don't forget that the paid leave authority is responsible for income replacement, wage replacement. But if you, as the employer, say to the person, look, you need to use your sick or vacation leave beforehand, before you go to the paid leave authority. And a lot of employers are doing this because it avoids something called stacking, which is that a person kind of hoards up their time that they have available from the employer. They go and they use another pot of time so that they could conceivably be out for extensive periods of time. So it's something to consider as you're putting your policies together. If you do offer short or long-term disability, some of them require that state available benefits are exhausted first, and that certainly is something that you'd have to adhere to in order to keep your policies valid. Now, what's important to know is that when the law changes next year, even though you can require an employee to use their sick, vacation, or other time, they must be allowed to hold on to 2 weeks of their time. They cannot be forced to exhaust all of the time they have available to them. All right, a little bit more about income replacement. Altogether, between whatever the employer offers and what we offer at the authority, those combined benefits cannot exceed 100% of the employee's regular wages. If they're receiving workers' compensation, that makes them ineligible for benefits from the paid leave authority. A person can receive paid leave without job protection because, remember, all they need to do is earn the 2325 in that time period that's prescribed, have a reason for leave, and be currently working or had been working 12 weeks before they apply. And they may meet all those criteria but not worked with you for 3 months. So they may have paid leave without job protection, but we need to let them know that so they can know whether or not they have a job to come back to. Some employers may indeed want to offer their own plan, and they can do so. That how you do so is on our website, and once the plan is approved, then the employer is responsible for managing all of the things that I'm mentioning here. A person who wants to apply for benefits from the paid leave authority, once they've received approval from their employer to take the time, would come to us. We would determine their eligibility, including their reasons for leave, whether they've met all of the other criteria, how much they've earned, and the like. We do a preliminary benefit calculation, and then we also contact the employer to make sure that you know that they're going to be away, and to see if there's any offsets or any other benefits that you offer that might impact the benefits they would receive from the authority. And then we pay the benefits. Formula for the paid leave benefits is in 2 parts. One is one applies whether or not the person, one applies when the person earns less than or equal to the minimum wage multiplied by 40. And that's pretty simple. And under those circumstances, the person receives 95% of their base weekly earnings. And so now the minimum wage is $12 an hour. It will obviously go up over the next few years, but that means that if a person earns $480 or less, then they will get 95% of their earnings. If they earn more than that, this is how the formula will work. They will get the $480, then they will get 60% of the difference between what they earn and the $480 added to that. But the most that they can get is $720 a week right now, or the most that they can get is always 60 times whatever the minimum wage is. Let's just take a little bit of time to look at a couple of examples of how this might work. So this is a larger employer. They have 30 employees working in Connecticut, and Mr. Coyote is a full-time employee. He's worked there for 10 years. So he does have job protection. He's been there clearly more than 3 months. He has 4 weeks of sick leave, 2 weeks of vacation time. He injures himself, non-work related injury, so there's no workers' compensation, and he needs to be out of work for 8 weeks. So we ask ourselves 2 questions. Is he eligible for job protected leave? And is he eligible for income replacement? And his scenario looks like this. Because he's worked for more than 3 months for the employer, he will enjoy job protected leave for the entirety of his absence. But because he does have time, and this employer requires him to use his sick and vacation before he goes to the authority for wage replacement, he will use 4 weeks of his sick leave, keeping 2 of his vacation, and the rest of the time he will come to the paid leave authority to receive additional wage replacement for the remaining 4 weeks of his family and medical leave. Now in September, he learns that his mother needs major surgery, and he asks for time to take care of her. He's earned 5 sick days, And since he's returned to work and he still has the 2 weeks of vacation, but now he's asking for another 8 weeks off. So again, we asked, does he have job protected leave? Does he have income replacement eligibility? And we can see here, because he's already used those 8 weeks, he does have 4 more weeks of job protected leave. And the employer is asking him to use an addition, one of those weeks for his wage replacement. And the remainder of the time that he has for the time that he will be away is he will receive wage replacement from the paid leave authority. But if you go back up to the first line, you will see that his job protection ends at the end of October. So while he's receiving wage replacement, he does not necessarily have job protection anymore. And this is an important distinction. I talked about a lot of things today, I know, but they're all available on ConnecticutPaidLeave.org. So we, on our website, which is ctpaidleave.org. And there we have a plethora of information. So we've got the employee rights poster, the RAC card, and the fact sheet. They all contain information about paid family medical leave for your employees in different forms. And these also are available in English and Spanish. Everything I've spoken about today is in a comprehensive 23-page employer toolkit that can be downloaded, also available in English and Spanish. If you have not started to take the deductions, the employee paycheck mailer that we have here is available for you to share with your employees so that this explains in a nutshell what the deduction is. They can also go to the website to the employee section and click on the contribution calculator and put in what they make, and it will give them an estimate of what that 0.5% or even the 1.5% might be. The best way to reach us is through the Contact Us portal on our site. We do not have a call center, and that is because we are just being very frugal with the contributions that are being sent to the Paid Leave Authority, and a call center costs millions of dollars. So we have opted not to do that. So you can reach us through the Contact Us portal. We also have just an abundance of information on the site to frequently asked questions and helpful videos. I thank you for your time. I'm going to stop sharing my screen and come back on to answer any questions you might have.
Andrea, thank you so much for the presentation. We do have a couple of questions in our QA. So let me go ahead and open that up. Our first question is, will the state of Connecticut employees be required to use their own accruals first before paid family medical leave?
All right. That's a complex question because there are many, many rules that govern how FMLA works in state government. And I am not as well versed as our general counsel is, who'd worked for the state for 15 years. So I would say generally, it depends on where you work. It depends on what the rule is. It depends on how long you've worked. And it depends on whether or not you are in a union that collectively bargains to participate in the program and what those rules are. So there are at least a number of factors that might apply. So I can't answer that directly.
Okay, fair enough. Is it mandatory for employers to allow employees to make a difference in payment between paid leave payments and their full weekly pay using PTO or sick time?
It is not mandatory, no.
Okay.
It's not, no. So if an employer, for example, offers let's say a short-term disability policy that pays 65%, unless it's your policy, you don't have to allow that employee to use whatever remaining PTO time, or you're not compelled as the employer to have them use the PTO time to make up the difference so that they can get the full 100%. That's part of the reason why we exist, is that if that policy only offers 65 and they want 100, they would come to the Paid Leave Authority for the additional 35%. And that's why the communication with the employer is so critical.
Okay, great. This individual is asking, I have more than one employee that will be taking maternity leave in the third or fourth quarter of 2020. At least one, if not more, will be on either bonding or pregnancy leave in January of it says 2021, but I believe they mean 2022 in regards to the statement.
Right.
These employees believe that they will be eligible for some paid leave. I am thinking that the leave event date, if the start date occurs in 2021, would not be the case. So
all right,
so asking here is, do they have to wait until after January 1st, 2022?
Yeah, so this is what we call in-flight claims, meaning they start in 2020 and then there might be some bridge over of eligibility in 2022. I'm actually reading your question again, so just give me a moment to work through it again because you broke up a little bit, Amber, so I didn't get the whole thing. So I'm going to read it again. So I have more than one employee will be taking maternity leave third or fourth quarter of this year. At least one or more will be bonding or pregnancy in January of next year. These employees, but they will be eligible for some paid leave, and that is true. They will be. They're thinking the leave event date, the start date. If it starts in 2021, would that not be the case? Well, here's what's interesting, and this is actually specifically because they're taking leave for pregnancy. Bonding can be taken for up to a year after the child's birth. So even if they were not eligible for pregnancy leave as for their own serious health condition, in both of these circumstances, they would be eligible to take bonding leave for up to a year after the child has been born. And so, yes, indeed, they are correct. They would be eligible for paid leave, even though they gave birth to their child in 2020 or 2021. Now I'm mixing up the dates. Even though they gave birth to their child in 2021, if they would be eligible for bonding up through whatever period of time that would be they would be eligible for in 2022. Now, the other corollary to that question is, well, what if it wasn't pregnancy or bonding? What if it was another serious health condition that they started in 2020 and 2021 and it kind of bridges over into 2022? This is actually, believe it or not, a question that the Department of Labor needs to answer because they are managing family and medical leave. We only offer wage replacement. So what they're saying right now is that if it bridges over, I want to make sure I get this right, and I may have to come back and correct myself. If it starts in 2021 and it bridges over into 2022, then you would treat the leave as if the law existed in 2021, unless there's a change in circumstance when the bridge is over into 2022. But they are going to they're looking to see whether or not that's consistent with how federal FMLA works. So I may have to come back and give you a more direct answer on that question, because that's believe it or not, that's not within our jurisdiction. That has to be decided by the DOL.
Our next question is: the old Connecticut sick leave still applicable, or did CTP leave replace the sick leave?
Excellent question. No, it did not replace it. It is still in place, but my understanding is that there's actually I think a supplemental or an additional paid sick leave law that's in place now that really just expands the categories of people who are eligible for sick leave. And I think it changes the number of hours from 680 to something that's much lower. I have the law. I haven't quite read it yet, so I couldn't give you all the details. But the sick leave law in the state has not been rescinded.
Okay. Our next question is asking, would leave start the fourth quarter of 2021?
No, the leave does not start until so let me put it a different way. The eligibility for paid leave benefits does not start until January of 2022. It does not. So our hope is that you'll be able to apply for leave by December, but there's no leave available until January. If you take a leave in December, you're taking it under the old current law.
Thank you for clarifying. We've had a couple questions on that.
Mm-hmm.
And the next one is between the federal and Connecticut time. If and only if the 12 weeks of federal or 16 weeks of leave was not exhausted. So could you maybe rephrase your question here a little bit? Because I want to make sure that we're answering you.
Yeah, or the other option, Amber, is if we can, I don't know, if we can have that person answer their question live, because sometimes that's helpful too. I don't know who that is.
I have you marked as an anonymous attendee, but if you wouldn't mind dropping your name in the chat, I can unmute you and we would love to answer these questions for you. We do have a comment that says, DOL, they need to catch up with us. We are all on it. Bravo. Thank you so much. We do appreciate that.
They've been a little busy and they're valued colleagues. So we're really trying to work with them, but yes, they will have an answer soon. They realize that this is an important issue as we get closer to the end of the year. They've actually been great to work with. So I will say that.
Okay. Give me just a second.
Sure.
And hi, Laura Lynn. Can you hear us? Can you unmute yourself?
I think so. Can you hear me?
We
Can,
can,
great.
thank
Thank
you.
you for agreeing to ask your question directly. I'd love to hear it so I can try to answer as best I can.
So you partially answered it, but I asked it horribly, so please forgive me.
It's okay.
I have been very clear because I think you guys have been extremely clear and helpful, and thank you.
Pleasure.
That people can start applying in the fourth quarter of this year that we're in
Yeah.
right now.
Right. It will most likely be December. I won't even say it. It's because the fourth quarter assumes it's September. It will most
Yeah,
likely
I'm
be
thinking December. Yeah, in my mind it was December, or I've heard you say that.
Yeah.
So I'm thinking, and I understand, but it's a little bit hard for me to wrap my head around that there's a difference between the paid leave and then the leave laws. I'm used to functioning in the leave laws.
Yes.
So if a maternity leave begins in the fourth quarter of this year, and I'm thinking earlier fourth quarter, more like in October, they will have exhausted their leave entitlement before, like the legal leave entitlement, the 16 Connecticut or the 12 weeks federal, by the end of December.
Yes.
So to me, that would, I don't know, would there be any leave entitlement to even apply to you guys for? Because they'd already used the legal leave entitlement, even in the case, like you said, with bonding. But even bonding would be included typically in that 12 to 16 weeks.
Right.
They're going to be continuous. It's not like they're going to be out planning for like 6 weeks and then come back and then do bonding. It's like going to be continuous for 2 months.
That is an excellent question. So, and there's a couple of answers to that, and I'm going to go back and check with our general counsel around it. So, because it's so funny, we were just talking about this the other day. So there's, essentially two scenarios. So let's say they take off the time for the pregnancy itself, right? Their own serious health conditions, so we'll consider it that way. And they've exhausted, because we're in 2021, we're under our current law, they've exhausted their 16 weeks and their 12, which can now run concurrently, because that's the other nightmare, is that you won't be able to do that as nearly as easily as you can.
I'm very excited about that.
I know. I understand. All I can say is I understand, and I can offer whatever apology I can. And we've already let the drafters of this law know that this is a problem, and somehow we're gonna have to try to fix this, because it's so difficult and almost impossible to run them concurrently this way, and that can be very problematic over time. So if they've exhausted that leave, then the only leave that they would be available that they could apply for in 2022, and then we would determine whether or not they would be eligible, would be bonding leave. But we're looking at rolling back, right? So if we do the rollback, they still won't be eligible until December, because it's only 12 weeks in a 12-month period. And if you count that, let's say October, November, or even November, December, let's say it's that last quarter, in that rollback period, they've exhausted their leave. So in the scenario that you're proposing, I don't see a circumstance where they would be eligible until they've worked through that 12-month period.
I didn't either.
Okay.
But did you get guidance on that from DOL? Because last time I asked, you guys hadn't decided, is it going to be rolling back?
Yeah, so no, so that was not so we did. I'm sorry, I didn't mean to announce that, but I just did. Yes, it's
sorry.
No, it's okay. Yes, no, we actually just last week we made that decision at the Paid Leave Authority. It is rolling baback. It is.
From the first day of the leave.
Right, from the first day of the leave. We talked to a lot of employers. Everybody uses a different. There's no way in the world we were using calendar. That was just never going to happen. But in talking to so many employers, it looks like rolling back is the least deleterious to their current policies. So that's why we landed on that.
Thank you. I was
You're
very
welcome.
excited to find that out. Appreciate it.
Okay, you're welcome.
All right. Thank you so much, Andrea. I'm going to roll it over to Frank. He has a few questions for you.
Sure. Absolutely.
Andrea, you're correct for a lot of our, in pointing out that for a lot of our SCORE clients, they may only have a very small amount of employees and don't even realize they're required to participate. I can't remember now. Can they, Is there a hotline again for them to communicate? Because a lot of them prefer to call and ask their questions.
I know they do. And I understand this is why
Trying
I'm
to
just,
understand the whole.
yes, I'm prospectively apologetic about the absence of a call center. It really, I'll just say it this way. We only have one source of revenue at the Paid Leave Authority, and that is a percentage of the contributions that are made to the trust fund. And I personally and my whole team, we are extremely conscious of how we spend that money because we know it comes from everyone's paycheck. Call centers are so expensive. They are, I can't even begin to explain what they cost.
Sure.
Just having 20 people answer a phone can cost up to $4 million. So
Sure.
which we don't think is really a good use of anyone's very hard-earned money. So we have a contact center in a partnership with United Way, which is just a fraction of that cost. But the way that works is that you go onto our site, you enter, you complete a form, and then you let us know if you want a call back, and then someone will call you within 24 hours with whatever the need is, if it can't be answered by email. And that's the way that we're managing it now. Unless there's some other way that our legislature might want to fund a call center, we don't think people want us using their money for that. We think they want us to use their money to pay benefits and not stand up a call center.
No, that's great. I think that the option to get a call back is very helpful.
Okay. Yeah. And also, Frank, let me just say that we are planning for an extensive campaign for small businesses because we clearly understand this. So we're actually working with our media partner now. We're putting together that campaign. It will include a substantial education component that will teach about what family and medical leave is. And so when I tell you don't panic, please don't panic. We know what the need is. We're working on it as we speak, and you will be okay. You'll be okay.
Great. Thank you.
You're welcome.
And Frank, I just wanted to let you and your members who have joined us today know, I did drop a link in the chat. So if you go down to the chat box on the bottom of your screen, the contact us portal that Andrea was just speaking about, I have linked that in there for you. So if you want to click on that and favorite place it and reach out to us, we are happy to help.
Great. So thank you, Amber, for that. And thank you for that reminder. Let me answer the panic-filled question that I just received about a person taking a year off for bonding. The answer is no, you may not take off an entire year for bonding. So there's only 12 weeks of leave that's available in a 12-month period. And bonding is not available on an intermittent basis. So you may not take off an hour in the morning or 2 hours in the afternoon for bonding. You only get up to those 12 weeks. So if you want to use 2 weeks of that after your child is born, if you want to use a month of that after your child is born, then that's what's available to you up to the cap of the 12 weeks. You may not take off an entire year to bond. What I said was that I may not have said as clearly, so I apologize for that, is that the eligibility to take bonding leave is available for an entire year after a child is born. So you may, as the birth mom, you may take the time, you may have your child, you may decide to go back to work, maybe go back to work for 2 months. If you want to take another 6 weeks to bond with your child after that, you're entitled to do that in blocks of time. And that's permissible. And then if you wanted to use your other 6 weeks for bonding or use it for some other serious health condition that's covered under the statute, that you can do that as well. But you may not take off, at least that we will pay for the Paid Leave Authority a year for bonding. Okay. So Frank, I think those are all the questions that we had.
Yes, that's great. Thank you very much. It's been very informative, Andrea, and really appreciate you taking the time to join us today. And
It's our pleasure.
We'll continue to communicate together.
Thank you. We appreciate the opportunity. Thank you, everyone, for taking the time to attend this afternoon.
Thank you all. Have a great day.
Thank you.
Bye.
Bye.
Now.